Good evening, ladies and gentlemen. I just want to check here, can everybody hear me sufficiently? And I'll try to make sure that I enunciate loudly enough for you, in case it doesn't. I want to thank you all for coming tonight, for those members of the press who came for this press briefing or conference. And there's questions as to why I'm using this particular format. With some of the issues that came up regarding the incident that happened in our jail back in September 20th of 2012, there has been some comments that were in the print media, both the Missoulian and our local Mineral Independent paper, and comments that were made in there that were not correct. I am not going to sit and decide whether it was not stated correctly, whether the people that were quoted incorrectly. Regardless of the point, is that there are people who have some misconceptions or misperceptions about this incident. And so rather than try to deal back and forth in the written press over what's going on, I wanted to be able to do this so that the local residents here, the voters who voted me in, would be able to hear from my mouth what's going on at the same time that the press is hearing it. And so that way there is no confusion as to what's being said, at least from my part. What you have, some of you already have a handout, and I apologize, this is not in a polished format. This was basically something I was going to be using as a format to cover topics, but with consultation I just decided to go ahead and use this for you. You can see what I'm going to be covering. And it was also, I believe, useful for the press. Wait for the train. Okay, can you hear okay now? So the first item I want to cover, before we get into the full incident, at least give you some background about the inmate in question. Because one of the items that I've been hearing in the rumors, particularly about this particular inmate and what had happened and the innocence or guiltiness, if you will, of this particular individual. In 2011, this particular individual, in December of 2011, had a minor in possession, disorderly conduct, and a temporary restraining order violation. January of 2012, was charged with criminal contempt. In March of 2012, was charged with criminal contempt and driving without a valid driver's license. In May of 2012, was charged with intimidation, criminal mischief, unlawful restraint, partner family member assault, disorderly conduct, and assault on a peace officer. And then in August of 2012 was charged with tampering with evidence. Subsequently, with those charges, he was arrested on December 24th of 2011, January 16th of 2012, March 5th of 2012, and May 11th of 2012. In the period of September 5th to October 20th of 2012, there were a minimum of 14 significant jail incidents or offenses. I want to cover some of the events that led up to the particular incident that occurred on September 20th of 2012. There were two separate incidents of the inmate actually tripping the fire sprinklers in the cells that resulted in associated flooding of the jail, flooding of the Justice Court, and part of the Communication Center. The inmate also had an incident with breaking the food port on the cell door in pod number 1, which required significant repair, and that door had to be removed to be able to put the door back on for the food port. In September 11, 2012, the inmate was able to release himself from the restraint chair. And September 13, 2012, tried to flood the holding cell by stopping up the toilet and turning on the water in the sink. and tried to hang himself with his trousers, which resulted in immediate consultation with mental health to have this inmate evaluated. On September 5th, it took 3 law enforcement officers, myself, 2 deputies, and the supervisor for the jail to subdue this particular inmate after the second time that he had tripped the fire sprinklers. Unfortunately, at that time, what had occurred was that the inmate was hitting the door, kicking the door, doing things that was placing himself in jeopardy of injuring himself. And so at that time, we needed to restrain that particular prisoner. And it took 4 of us to do that, and not easily. The point is that this inmate, even though he was small in stature, was very strong and very capable of providing significant resistance. The incident that occurred on September 20th, 2012 was a result of, during the evening meal, the inmate had been kicking his holding cell window, was throwing food at the video camera, had been throwing food at the wall, threw condiments against the wall, was writing obscenities against the wall, and covered the video camera that we needed to use to observe him. Understand that the time that he tried to hang himself was not the first incident. And he had covered the video camera with yellow legal paper. At that time, the detention officer on duty felt that the inmate needed restraint and called for the 2 deputies that were on duty that night, which were Deputy Lipinski and Deputy Balenger, to assist with this particular inmate. During the attempt to place him in the restraint chair, there was some resistance during securement, and this was when force was used by Deputy Balenger in striking the inmate and using the taser in what we refer to as a drive-stun mode. The cartridge is removed from the electronic control device, and the 2 contacts are placed against the skin to try to obtain control of a person who's resisting. After the drive-stun mode was used, the inmate stopped resisting. As a result, that particular incident was videotaped, was reviewed by the county attorney, and at that point she initiated an investigation, or contacted the Division of Criminal Investigation to initiate an investigation to the incident. The investigation then was initiated in October of 2012 by the Division of Criminal Investigation. And the length of time that it took to do the investigation was solely at the discretion of DCI, Division of Criminal Investigation. And there were questions by a lot of people as to why it took so long. And that was out of our control. For whatever reasons, I have to admit that the Division of Criminal Investigation is a very busy agency. They do not have a large force, and so consequently they need to prioritize their assignments, and at times may have to leave a current assignment. I'm not taking questions at this time. They have assignments that they may leave for one that has a higher priority. And so those incidents do take a period of time. I did skip number 5, and I apologize. When Deputy Balenger was placed on administrative suspension in October 2012, and that was with full pay, and that was on the advice of the county attorney, who had received that from the Montana Association of Counties Attorneys, who is our liability carrier. In June of 2013, the county attorney received a letter with the conclusions from the Assistant Attorney General, Mr. Brent Light. And subsequent to receiving that, myself, the county attorney, and 2 attorneys from the Montana Association of Counties, Mr. Mike Seystedt and Ms. Maureen Lennon, discussed during the telephone conference the appropriate discipline that would need to be executed. At the time that we discussed that, there was no discussion about problems, and from my understanding, because there was no objections, this was the discipline. The letter that we received from the Assistant Attorney General, and I believe this was already in the media, the recommendation from Mr. Brandt Light was that the discipline would be at the discretion of myself and the county attorney. The decision then from the four of us was that Deputy Balenger would receive 5 days of unpaid suspension. There would need to be remedial training in the use of force, and there would also be some remedial training that is still yet to be arranged by the Montana Association of County Attorneys in conjunction with Montana Law Enforcement Academy for all review for all our deputies and for detention officers. That is still pending. The suspension and the remedial training occurred in July of this year. The training was performed by the Montana Law Enforcement Academy Certified Use of Force Instructor, and Deputy Balenger then returned to work at the end of July. In July 26, 2013 was a letter dated from the Mineral County Attorney regarding Brady versus Maryland issues in the case of Deputy Balenger. There is for some folks, confusion about what Brady versus Maryland actually states. I don't have it verbatim here, but in essence, the county attorney is obligated that if there is evidence regarding actions of a particular officer and could be exculpatory for the defense, that information needs to be provided to the defense attorney. There's no question that for the use of force incident is a Brady issue. I don't believe at this time that the credibility issue that is being brought up by the county attorney in regards to Deputy Balenger is an issue. There has been no documented discipline that has been given for untruthfulness or lying, as some would put it, or deceitfulness in any other investigation that would lead to a Brady issue. What I do have here is from a state attorney. I will remain unnamed. The Brady versus Maryland states that a prosecutor is required to notify defendants when an officer is involved in an investigation, was disciplined for knowingly lying in an official capacity in any other case. And if I have ever disciplined the deputy for knowingly providing false statements, the county attorney would be required to notify the defense counsel when the officer was involved in an investigation. That is not the case here. I would like to address some issues now for statements that were in the Mineral Independent in an article dated September 4th of this year. The statement that was in the article, as being quoted by the county attorney, was a statement that the county attorney and the commissioners had expressed to me displeasure with the disciplinary action that was given to Deputy Balenger. The only thing that I had received from the county attorney was that she had sought termination. At no time did any of the county commissioners, either in writing, verbally, or otherwise, express to me the displeasure with the 5-day suspension and the remedial training. During my conference and the county attorney's conference with the two attorneys from the Montana Association of Counties, she never expressed at that particular time displeasure with the 5-day suspension, and our liability carriers felt that the 5 days was sufficient. So finishing up in that particular portion, the discipline was approved with the consultation of our liability carriers and the county attorney, and was done appropriately. As to some of the issues that came up in an article from the Missoulian, the amount that was stated during the suspension needed to have a caveat that included all the benefits, and that was not the amount of pay that the deputy actually received. So the calculation includes everything that would be paid out, but not necessarily what the deputy would receive. I have instructed my deputies to perform their duty to the best of their ability. I've already discussed the Brady issue here. I feel it's irrelevant in the case of credibility, and that it is the county attorney that has stated that she is not going to prosecute Deputy Balenger's cases because of credibility issue. The removal of Deputy Balenger from the sheriff's office has not been discussed with me by the county attorneys. With permission of Deputy Balenger, I will state that a closed hearing was held with the county commissioners, with some other witnesses, and myself and the county attorney, and at that time, the county commissioners did not express any particular opinion as to removing Deputy Balenger. There was a statement that was stated in the Missoulian from Commissioner Simons regarding Deputy Balenger, and this was not addressed by he or any other commissioner during the closed hearing. And again, in relating to the credibility issue, that's already been addressed. Also in the Missoulian is a statement credited to Commissioner Lori Johnston in regards to Deputy Balenger's credibility in the case of some type of rape or child molestation. And in essence, that would not be correct. Those cases immediately